Hello and welcome to Advanced Trial Tactics. How do you get those punitives part two? And speaking today or this evening, we have Lynn Fiorentino and Malcolm McNeil, who are both partners at Aaron Fox. Malcolm is our beloved past president here at VHBA and has over 35 years of litigation and commercial experience in a wide variety of matters, including business and commercial, construction defect, employment disputes, administrative proceedings, trade secrets, probate, media and entertainment, intellectual property, partnership dissolutions, and real estate. Malcolm has 25 years of experience resolving civil suits as a mediator and is a paddle mediator for the United States District Court, Central District of California. And in addition to his litigation experience, he has litigated a wide variety of business disputes, including those for venture capital formation, retail, entertainment, textile, manufacturing, import, export, real estate investments, aviation, and publishing. He is keenly aware of the legal and business needs of his clients and provides strategic solutions to commercial disputes that help enable its clients' businesses to keep moving forward. He also has experience in cross-border negotiations and has an established network of colleagues globally, assisting foreign countries as needs arise. Malcolm's practice has included representations of clients in most forums, including administrative forums statewide and nationally. Known for his leadership and accomplishments, particularly for his clients with business interests in China, Malcolm is a panel member of the Shenzhen Court of International Arbitration, the Beijing International Arbitration Commission, and the Harbin Arbitration Commission. Malcolm has also served as a co-leader of Aaron Fox's international group. I'm sure I've missed several groups that Malcolm is involved with because it's very extensive. And Lynn Fiorentino. Lynn is also a partner at Aaron Fox, and her diversified practice allows her to function as a trusted advisor to companies and individuals across a broad array of industries and practice areas, including the consumer product space, all forms of civil litigation with a focus on class actions and Proposition 65, and white-collar commercial litigation and government investigations. In the civil arena, Lynn defends cases involving alleged financial fraud, employment and wage hour violations, unfair competition under Business and Professions Code 1700, and Prop 65 violations. Lynn also represents alcohol beverage suppliers and distributors in breaches of contract and business tort litigation. She has extensive experience in drafting pretrial motions and setting up cases for trial. In the criminal area, Lynn represents clients in the defense of the Foreign Corrupt Practices Act, False Claims Act, Clean Water Act, and money laundering and antitrust laws. She also defends students in Title VII university disciplinary matters with parallel criminal proceedings. Lynn has extensive experience defending business organizations, employees, and witnesses, and representing victims in government investigations and criminal actions. Her broad experience also includes conducting internal investigations in white-collar matters and governmental investigations and interfacing with state and federal prosecutors. Lynn has criminal trial experience in state and federal court. I am super impressed, and I'm looking forward to part two. There's a lot of really good information here today. We're glad you could come.
Well, thank you for that introduction, Hillary. That was fantastic. And yeah, I'm sure you left some things out in talking about my background, but I'll forgive you this time. No, that was very, very nice. This is part two of a program that we started earlier this year, and we put it together because there was a growing interest among practitioners on punitive damage issues because of a slate of cases that came down. The great news, by the way, besides hearing about our being partners in the same law firm, Lynn and I are very good friends. We've tried cases together. We've worked on cases together, and that's why we wanted to do this program together, because we watched how other practitioners deal with the issues of punitive damages during trial and in pretrial motions and motions in limine. And it was a great area for us to also research, and we actually learned a little bit. I can tell you that as we prepared for the program. So what we're going to do today is we're going to do a brief overview of the first part of the program, and we tried to break off the last part of the program to deal with the hypothetical situation so that we could give you some practical tips as to what other practitioners have done in the past. So as you can see, this was today's agenda at that time. And we started with what constitutes malice, oppression, despicable conduct, and we established the basics. We brought all of you into a discussion over the Casey jury instructions 3943 and 3945. And let's move to the next slide real quick. and we talked about what malice is and how that works because it's an intentional action that you're trying to prove in court with a knowing disregard of the rights of others, and you hope to find and elicit the facts during discovery that will support a finding of malice so that you can argue credibly to a jury. Or alternatively, if you're on the defense side, you want to be able to say there was a lack of malice. You want to be able to say there was no malice here. There may have been a mistake. There may have been something that transpired, but there was no intent to cause injury. Injury may have occurred, but it was not something that my client wanted to have happen, nor did they do it in a willful disregard of the rights of another. So and to the next slide, please. The same with oppression, because oppression is finding the case where you want the jury to be outraged by the action. You want the jury to find that it was despicable what occurred and that the plaintiff may have been subjected to cruel actions, cruel in some cases a persistent group of actions that occur over a period of time, all done in the knowing disregard of the plaintiff's rights. Next slide. Um, Despicable, we talked about despicable conduct is any conduct that is, these are important words, folks: vile, base, or contemptible, that would be looked down on and despised by reasonable people. Now, I'll tell you where I've seen practitioners make mistakes on this is they'll throw everything into the discussion and say that that is vile, base, or contemptible, or despicable. Choose your facts wisely. Don't throw everything into the mix when you're arguing it, because if you throw in, let's say, less offensive conduct and try and claim that it is despicable at trial, you're going to lose the jury because they're going to say, well, that's really not despicable, so maybe that isn't, and maybe that wasn't so bad. So choose your facts wisely. More is not better necessarily unless the conduct that you're complaining about and arguing to the jury is consistent and similar and has the same type of effect on a jury for a jury to find it is reprehensible. Next slide, please. Fraud. The fraud means that a defendant entity intentionally misrepresented or concealed a material fact. This is one of the easiest things to find, by the way, in a case, because if you're conducting discovery as we do under our system, as exhaustive as it is, you're going to usually be able to find something that you can characterize as fraud. Whether or not it is actually fraud, you're going to have to argue that fact. And again, I tell you to be cautious on the plaintiff side. Make sure that you don't find I'll refer to it as innocent misrepresentation or concealment as a fraud, because if you do that, you may lose the jury, because they're going to say, well, I can understand how that was a misstatement, or that may have been a mischaracterization, or whatever. Choose your facts wisely. Get a good fact of fraud, such as something right on point that shows it was concealed, and we'll talk about that in a little while when Lynn talks about the findings in the Monsanto case.
Yep. And Malcolm, if I could just interject for just a second, this is great.
Sure.
Just a reminder for everybody with fraud, you have got to plead it specifically with specificity as to the who, the what, the when, the where, the dates, all of that. If you're gonna base this on a fraud claim, you've got to have the particularity there, or it's going to get thrown out potentially on demurrage. So just a reminder for everyone on that point.
Lynn, absolutely true. I've seen cases thrown out where counsel have not elicited enough facts from their clients. Sometimes, and I learned from an experienced practitioner a long time ago, he had his clients write out a statement and say, write out a statement from beginning to end in your handwriting, and I want 5 pages. 5 pages of getting the client to put down everything that they didn't necessarily provide in an oral interview with the lawyer. Because as Lynn said, sometimes those facts are elusive, although if you end up sitting down and thinking about that, you'll be able to allege the specificity, the dates and names and who took down numbers, etc. But so do your homework ahead of time before you start crafting the complaint. Okay, next. So punitive, then we went into a second phase, which was the punitive damages against the employer or principal for conduct of the employee. This is a next slide. You'll take a look and you'll see jury instruction 3943. And in 3943, it says that the plaintiff must show by clear and convincing evidence that the employee, the agent or director or whomever of the company was acting on behalf of the entity, which is typically the easiest thing to prove. The next one is that the entity knowingly employed an unfit employee or agent, which is a little bit harder to prove because you're even if you get a personnel file and you succeed in doing so, you may not find that they actually knowingly employed an unfit employee, so you need to dig for that information. You also need to show that the employer authorized the conduct, which is also another one that is challenging when you're trying to prove it. And finally, that the defendant entity knew of the employee's wrongful conduct, but they approved of that conduct in some manner. That can also be by after acquired facts. If an act occurs and they don't take any remedial action against that employee, that itself can be deemed to be approval of the conduct because they did nothing to remediate the situation. And the defendants, very easily on the bottom, the defendant can contest this with clear and convincing evidence that we didn't know what was going on with that employee. This was a one-off act. This was we thought he was okay. We thought she was going to do well. We thought that he was this. The employer is going to say that they did their appropriate pre-screening of the employee, had no idea, no prior complaints, etc. That's what the defendant's going to have to prove. Then we turn to the KC jury instruction 3945, our next one. And that is that punitive damages can only be awarded against a defendant entity. I'm sorry, but all of a sudden on my screen, it popped up everybody's picture. Punitive damages can only be awarded against a defendant entity only if the plaintiff can prove by clear and convincing evidence that one of the things we've already talked about exists, and that is that you need to show malice, oppression, or fraud. And by the way, the standard is clear and convincing evidence. The conduct was committed on behalf of the entity, etc. The defendants must show, again, in converse, that that by clear and convincing evidence that the conduct was taken and was absolutely independent of the policies, the procedures, the manuals, whatever was in place in the employer's instructions to its employees and whatever was on its website talking about its responsibilities to its customers or clients, etc. So the defendant needs to say, well, no, these are all of our policies. We had them out there, and in our policies, it's violated all of them. So we did not in any way ratify, condone, or approve the conduct. So then we get to a very important, this is what the next slide is, determining punitive damages under both of these. Now, this is the area that we're going to be focusing on a little bit, and this is right where we just about broke off the first time we all met. And that was that the plaintiff can use a variety of factors in order to show and enhance the nature of the actions and get a larger punitive damage award. Whether the conduct caused physical harm or not. We were having a discussion of this offline, and juries are obviously more likely to award if you're able to show the oppression, fraud, or malice. If there's physical harm, they will tend to enhance the punitive damage award more than they would in, for example, a financial loss. If there's a fraud and the money has been stolen. So keep that in mind, that physical harm is always has more emotional appeal to a jury, because it can be argued in a financial situation that compensatory damages are enough. They may have lost $450,000 as a result of the defendant's stockbroker's conduct, but an award to award that plaintiff the $450,000 plus interest is an appropriate response. They will get their money back. Punitive damages are not appropriate. And that argument can resonate with some jurors. Whether the defendant disregarded the health or safety, you're going to see a little bit of...
Malcolm, just to throw in, I was just going to throw in a couple of examples on the first point, the physical harm, just to give the audience a sense of what we're getting at there. When you think back to the 1970s and the Punitive case, right? We talked about this case kind of seriously injured, in some cases killed. That's going to be a situation where likely you're going to get punitive damages, right? Particularly if the company could have changed, say, the design of the product, but they decided not to because of cost. Those types of facts are going to be ones that are going to make the company or the defendant in that case vulnerable to punitive damages. So I just wanted to throw out an example there. Another one that I saw a lot early on in my practice in the asbestos litigation arena was punitive damages, awarded in those cases where companies were alleged to have known of the hazard of asbestos back in the 70s, and yet they still used it in their products. And lo and behold, plaintiffs were getting, cancers and mesothelioma some 20, 30 years later. Those are the types of cases, I think, where that physical harm element really, is illustrated. Not to interrupt you, Malcolm.
No, that's fine. And I think the Pinto case is a great example, because I think that if you go back, and for those of you that may be too young to have remembered what happened with the Ford Pintos, do some research, do a Google search on the Ford Pinto litigation. In that case, all 5 of these factors were met. The conduct caused physical harm. The Ford had disregarded the health or safety. The plaintiffs who bought the cars were not rich folks. It was an economic car. It was a car meant to be sold to a certain segment of the public. It involved a pattern or practice. They knew what was going on and continued to allow it to go on. And there was trickery or deceit because it was never disclosed to either to the dealers or to the general public. So moving to factor 2, whether did they know the risks? Maybe we should use the Pinto case, Lynn, and discuss it from that standpoint, that the defendant knew the risks and chose to proceed. They had proof that there was a problem with the car, and that if it was rear-ended at a particular speed, a bolt would penetrate the gas tank and the car would explode. With that information in hand, they elected to proceed forward anyway. They attempted to hide this. Go ahead, Lynn.
Yeah, I was going to say, Malcolm, just giving another example in asbestos context, right? The companies that were making these products back in the 70s, and some of these were, products you use, insulation, things in your home or in a shipyard or whatever. They knew based on studies that there were, human hazards to being exposed to these fibers, but they still included them in their products for a number of years after that, after having that knowledge. So again, knew of the risks, chose to proceed. So just to give another example there.
Sure. No, perfect. And that's going to be a good segue into your segment here, Lynn, because the third element here says the plaintiff should seek evidence where the defendant did not adequately disclose contributions in an effort to shape scientific inquiry. And that leads us into the next slide, which is showing us a hypothetical, which is where we wanted to begin today's new information. And the facts of this case are on this slide. And I'm going to turn it over to you at that point, Lynn. It's all yours.
Great. Thank you, Malcolm. That was a terrific recap. And I think it gave everybody kind of a reminder of what we're talking about here, from fact, fraud, malice, oppression, to now getting into, how do we prove or defend against these claims? So our first hypothetical here, and this is a case that some of you are probably going to remember because it's actually several cases, but the one we're talking about here was not all that long ago. And here's really the key fact. So in 1974, Monsanto, which is the company that makes the weed killer, Roundup, which, if you're old enough to remember it, I remember my dad using it in the yard on the weekends to kill weeds. Remember it very well. That company received approval from the EPA to sell glyphosate-based herbicides based on invalid studies examining the cancerous effects of glyphosate on animals. Glyphosate is obviously a chemical. It over time has been shown to cause cancer in animals, and I believe later in humans, and has been a source of controversy because of that. Despite the EPA's findings that the study was fraudulent, Monsanto did not remove the product from the market. In 1983, a new study showed that mice exposed to glyphosate were more likely to develop kidney tumors. You see this a lot too with these types of cases, right? Where there's animal studies done linking a chemical or chemicals to a disease. Often it's cancer, lymphoma, something like that. And despite knowing that those studies exist, the companies still go on to sell the product. In some cases, and I can remember this happening in the asbestos context, the companies would claim, well, those were just animal studies. They're not human studies, so it doesn't really matter. We'll see about that. But getting back to the fact pattern, upon showings that the EPA planned to classify glyphosate as a possible human carcinogen, Monsanto hired a pathologist to persuade the agency that the observed tumors are not related to glyphosate. The APA was not convinced by the pathologist and requested Monsanto to perform a new mouse study and worked with them to design the study, to which Monsanto did not do. Then you jump ahead to the 1990s, where Monsanto retained an expert in genotoxicity to review studies that Roundup has genotoxic effects, to which the expert concluded that glyphosate is capable of producing genotoxicity. Monsanto sent their own studies to the expert. The expert recommended additional studies to resolve issues concerning the genotoxicity of glyphosate. Monsanto performed only some of the recommended studies. In internal emails regarding the genotoxicity expert, Monsanto toxicologists stated that they were seeking experts that could be influential supporters, and that their current expert was not it. Okay, so they were expert shopping. They were looking for an expert to say that glyphosate is not carcinogenic. Monsanto, suggested a backup supporter, admitting that they were vulnerable in the genotoxicity area. And I think that's where the fact pattern on this one ends, although I'm going to give you a few more tidbits, the audience, just so you're aware. What was really interesting, I think, about this case is sort of the knowledge and the cover-up. You had a senior toxicologist, at Monsanto in 2003, who wrote in an internal email that they could say that glyphosate is not a carcinogen, as they had not done necessary testing on the formulation to prove otherwise. 5 years later, in 2008, that same senior toxicologist was sent an email regarding a press release on a study showing that glyphosate could double the risk of developing lymphoma. Wow, right? In their response, they stated that they were aware of the results and that they knew it would only be a matter of time before the activists would pick it up. It's a pretty damning email, piece of evidence. If you're Monsanto, you're the defendant in this case, you better be very concerned about that. And if you're the plaintiffs, in this case, this was a husband and wife plaintiff, patients who had developed lymphoma allegedly from exposure to Roundup. You're going to be very excited to have received this email, discovered it in discovery, because it's going to show knowledge. It's going to show a cover up. It's going to show a disregard for the safety of other people. All the factors that Malcolm outlined on the last couple of slides. I mean, this case is it. And just giving you a few more of the facts, the courts in 2001, the California Court of Appeal issued the decision in Pili versus Monsanto Company, finding that there was a substantial evidence demonstrating that Monsanto disregarded the health and safety of others. I think it's clear from the facts that we went through. There were other facts as well that really were damning to them. Monsanto did not disclose its contributions to published articles, finding no link between glyphosate and cancer. They engaged in ghostwriting, where they would write sections of articles that outside experts would just edit and sign their names to. And it was not until 2015 that glyphosate and Roundup were fully considered a possible human carcinogen. So until that time, we had the animal studies, we had the EPA coming out and saying, well, we think it may be, and we need to dive deeper into this. what's really fascinating about this case is that the husband and wife were each awarded $1 billion. So total $2 billion in punitive damages. I mean, this damages and why and how they get awarded by juries. You can imagine the sympathy that these plaintiffs elicited, a husband and wife who, presumably use this product out in their yard for years and years, and they both developed this horrible disease. They were, incidentally, husband and wife were also each awarded significant compensatory damages. And so one of the things we'll talk about is, what is that magic number or ratio between the compensatory and the punitive? And the State Farm case that most of us, I think, studied in law school, we're familiar with. In that case, the Supreme Court, the United States Supreme Court, held that a ratio of 6 to 1. So 6 times the amount of compensatory would be the cap for punitives. In this case, the wife was awarded $56 million in compensatory damages and the husband $31 million. These are substantial numbers. And I think the facts just underscore, again, why Monsanto was awarded punitive damages in this case, the knowledge, the cover up, the deceit and trickery. I think, Malcolm, to your point with that slide, this case really has all those bells and whistles in it. So I'll stop there.
Yeah, and just a couple of comments. Everything is there. I remember one commentator saying that there was a whole group of things that Monsanto did wrong, because besides the sympathy that was elicited for these plaintiffs, there was outrage against Monsanto. Not just the plaintiffs who suffered the injuries as a result of this product, but Monsanto's that compounded the factors that we've already talked about, and they all came through, and they all became a series that the plaintiffs' counsel was able to put together and put before the jury. And one of the ones that in one of the commentaries, they said that the jury, they argued to the jury that there was intentional ostrich behavior by Monsanto. And it was not just passive ostrich behavior, but intentional ostrich behavior, and used an example of the fact that yeah, when you see that something bad is about to happen, you intentionally avoid doing anything about it. And that apparently was one of the strongest elements that Monsanto was able to or fell on as a result, which caused those verdicts to occur. So,
and, I was just going to say too, Malcolm, that the Piliad case is obviously not the only one, right? So there were a number of other lawsuits brought by different plaintiffs, around the country against Monsanto that have also resulted in punitive damages, along the same theories over time. And I do have to apologize, because I realized I should have raised the question for the audience first. Is there sufficient evidence here to support an award of punitive damages? And it might be fun on the next hypo if we raise the question and let people write in the Q&A to see what they think. So
well, that's right. But this one would have been too easy for our esteemed colleagues, Lynn. I mean, because it's jam packed with a lot of awful stuff. So, and I also recommend for those of you that don't know, Bayer had purchased Monsanto at some point in time, and they vigorously started fighting some of this litigation. So for those of you that want to learn a little bit more about the history of this litigation, check it out online, and you'll find a site that I think that I believe it's Bayer that put it together, but they talk about the litigation and what they were doing in order to defend against the cases as time passed. So for those of you that want to be nerds in the area and see what the defense is.
Seems like a hard case to defend against, but it would be interesting to see what their theories and strategies were on that end of it, on the defense side.
Well, exactly. So now turning to the next slide, and Lynn, if you want to pick this up,
yeah, let's go. Sure.
Do we want
to go to the next slide, please?
Yeah, I think I think we should go to this is one of my favorites when we were preparing, I think. So what do you think? Okay. Is there a reasonable relationship between the amount?
Sure.
of punitives and the plaintiff's harm. Well, Lynn just gave you in the Monsanto case the actual or the compensatory damages, and I think we've already talked about it in the past, and that is there has to be some rational relationship between I won't say rational actually, I should say relationship between the compensatory damages and the punitive damages awarded. So do you want to hit on that a little bit, Lynn, or would you like me to?
Sure. I mean, I'll just reiterate that in the State Farm case, right, Supreme Court said 6-1. Punitive damages could be as much as 6 times the compensatory. I've seen other cases with slightly different numbers. Malcolm, I don't know if you want to comment on that at all, but I always refer back to State Farm because I just feel like that's sort of the gold standard in this sort of area of capping and things like that.
It is, but it's funny. I'm recently licensed in the state of Washington, and I know that the state of Washington has been quite liberal in upholding damage awards that are beyond the 6 or even in the 9-1 range, which is what we were hearing was the upper range in the Supreme Court case. So I think what we need to reiterate at this point for everyone's benefit is whether or not you're seeking a large punitive damage award in a case, focus on your compensatories. Do what you need to do to show that the compensatories are sizable, significant, that the plaintiffs are going to need whatever treatment or remedial help that they're going to need. They may need, and all of the typical things that you would look for in a typical personal injury setting. And you would want to make sure, because if that figure is larger, and you have grounds for punitive damages, then those grounds for punitive damages will be a factor in relation to the compensatories. So if the compensatories are not developed well enough at trial and the jury doesn't quite see it, but is sympathetic and awards the plaintiffs a nominal sum of money or a more modest sum of money, but they're also award punitives on top of that, the punitives will be limited to some degree by the compensatory. So don't spend so much time focusing on your punitives that the compensatory side of your case suffers.
And I think too, this kind of goes back to a point we discussed in the earlier presentations that we've done for this series for the advanced trial tactics on business torts, and that is really developing your facts in discovery as to the compensatory damages. If you're on the plaintiff side, right, retaining those experts early, getting if it's an injury case, getting the medical records, getting the incident reports, all the things, the witnesses, everything that you need, because you want to be able to demonstrate as much as you can on the compensatory side and for as long of a period. So in other words, if you've got your client has some type of an injury that's very serious and they're going to require treatment for the rest of their life, let's say, I mean, that's going to be a much larger, right, compensatory case, which then folds over into your punitive case. So I think developing those facts early, not waiting until you get to trial, is going to be really critical when you're looking at these types of issues.
Well, and that's a good lead into our next slide, because the next one talks about, in view of the defendant's financial. Let's go to element. Forget the rest of element 2. I think Lynn's covered that. Let's go to element 3. In view of the defendant's financial condition, what amount is necessary to punish and discourage future wrongful conduct? Plaintiffs should be prepared to argue this is not grossly excessive, because look at how much money this defendant has. If you award $100,000 and the company is in the Fortune 50, it's not going to make a difference, and you're not going to deter this conduct in the future, and it's just not enough money. And so as a consequence, you need to be able to show that. And defendants have become, I've watched how they've been defending against these, is that when it goes to showing the actual value of the company, the question is, what is the value of that particular company, not a group of companies? As you'll note, they try and slice and dice and divide up the conduct and sales and activities of each of the companies into separate corporations, so that it reduces the size of the company for purposes of the grossly excessive standard that the plaintiffs have to show. So they're going to say, oh, they have multi-billion dollars of assets, and it's no, they don't actually. This is the Newco Marketing Corporation that is the defendant here, Newco Marketing Corporation, it is not worth billions. It has a net worth of $9 million or whatever it may be, to show that it should not be, and therefore if you award a lot of money against them, you can put them out of business. It would be grossly excessive to put them out of business as a result of this lawsuit. So that's the give and take between the plaintiff and the defendant during the trial. I had that.
And I think here, that's a great point, Malcolm, because I can think of cases we've been involved in where maybe the plaintiff is going to argue, look, we should look at the financial condition of the parent, right? And all the companies that fall within that parent, not just the one entity that was involved here, the Newco Marketing Co, as you said. So if you're the defendant, you're trying to limit the universe, and if you're the plaintiff, you're trying to enlarge it, right? I think one thing that's really important for this here is just to remember punitive damages. The point of them is to punish the defendant and to deter that conduct in the future. So in cases where you have repeated or patterns of conduct where the defendant has engaged in this conduct previously, that's a tough case for the defendant, right? And it's going to most likely result in a punitive damage award that's not going to be pleasant. So it sort of underscores the fact that if you're representing a company and they have made a mistake and they've done something wrong, the remedial aspect is critical on the first go around, and fixing it so that they don't have this sort of pattern and practice theory alleged against them later on, whatever the case may be.
Exactly. And on the next slide, we talk a little bit about what the defendants need to do in order to limit damages. So go to the next slide. You'll see the defendants can limit the damages by showing that the plaintiff was fully compensated. That goes back to the comment that I made earlier in the stockbroker case, where the stockbroker committed fraud, and the defense argues, well, a compensatory award is going to be enough. They've been fully compensated if you give them that award. And so that's a stronger argument in a financial punitive damage case than in a personal injury punitive damage case. And the compensatory damages are not unusually small or hard to detect or difficult to measure. No, we know that that account, the stock brokerage account, went from 436,000 to zero. So that's a quantifiable number, and that's a sizable number, and that's a large number, and they should get that amount if you decide to award that, but they should not be given a bonus as a result of that. And also to say that it wasn't the stockbrokerage's idea, it was a stockbroker who may have been errant in his or her advice to the customer or client, but they didn't intend to cause that harm. Okay. And this is a one-shot deal. Nobody said that this happened to a group of investors, or that it was a practice and policy and procedure of the company to churn all these accounts down to zero. No, it was not. So those are the kinds of things that can mitigate the impact of the conduct that may lead to punitive damages.
Great point, Mark. And one thing I wanted to just, and it doesn't necessarily fit in here, but I wanted to just mention for the audience that, it is fairly common for judges to reduce both the punitive and the compensatory damages on appeal or at some later proceeding. We saw that even in the Monsanto case, the compensatory damages were reduced slightly on appeal, not significantly, but they were reduced. And so it shows that the judges really, do have significant discretion here. And if they believe that a plaintiff has been overly compensated, whether it's through the punitives or just the compensatory damages, that they can take that into account and reduce those awards at a later proceeding.
Let's go on to the next slide. Yeah.
Next slide. I think we've got another hypothetical here. And do apologize to the audience because it looks like we've got the wrong verbiage on the left-hand side because we're still referring to Monsanto. So just ignore that. And I think it might be interesting on this one to just go through the facts and then have the audience vote whether there is sufficient evidence here to award punitive damages.
Yeah.
What do you think about that?
I think so too. We can go. Let me give an intro, and then I'll let you run through the facts.
Sure.
This is yet a different kind. We've talked about dangerous chemicals. We've talked about financial cases, etc. This one is a hospitalization policy. This is one of those. It's in the category like disability insurance policies. I've litigated those cases where the company has denied disability benefits to, and I've been on the plaintiff side of those, where they denied benefits because they believe that the insured was still able to work or didn't meet the definitions of disability under the policies. And those cases are dangerous cases for the insurance companies to deny coverage on, because if they do, there's typically an expert somewhere which will say that the plaintiff was limited in some fashion. Here you had an interesting case involving someone who's already injured who is a sympathetic plaintiff. So this is sort of in the same lines, because in the disability cases, what I was able to show was the deteriorating financial condition on my client as a result of the continued failure to pay the disability benefits, and that continued decline in my client's standard of living. And things changed very dramatically. As a result of that, the insurance company ultimately settled on the courthouse steps. And this is similar to that in terms of the sympathetic plaintiff. So I'll leave it to you, Lynn.
Interesting. Yeah, sure. That's a great intro to it. So in this particular case, Stonebridge, an insurance company, insured Nickerson under a policy that provided, and Nickerson is the patient here, under a policy that provided $350 a day in coverage for hospital confinement for covered injuries. $350 a day for confinement in intensive care, and $150 per visit to the emergency room. So, as most of you probably know, insurance companies are very, very strict and persnickety about what's covered and what's not. And the
Lynn, you're going to need to repeat it because you're breaking up a little bit. Apologies to the audience. Lynn is getting.
constituted necessary treatment.
Lynn, go back and yeah, there you go, because we lost some of your audio there.
I apologize.
No worries.
I apologize. I'm going to just turn my video off there for just a second, see if that helps. Okay, so I'll repeat the last couple of facts. So the carrier had certain criteria that had to be met as to whether certain treatment would be considered covered under the policy as necessary treatment. And they had a specific definition of what constituted a hospital stay under the policy. So Mr. Nickerson is a vet. He served in the Marines. He was entitled to stays at the VA at no cost. And sadly, he became paralyzed in 1997 from the chest down in an accident. And so about 10 years later, he fell out of his wheelchair and he was treated at a VA hospital for injuries. He was first in the emergency room, then in a spine.
Lynn, why don't you turn off your camera?
Can we go to the next slide, please?
Yeah, Lynn, we didn't get any of that. You may want to turn off your camera.
Right. Okay, I'm going to turn off my camera, and I do
Okay.
apologize to everybody.
No worries. It happens.
Okay, good old internet connectivity. So the patient here, Mr. Nickerson, he served in the Marines, and he was entitled to stay paralyzed in 1997. Down, and about 10 years of 109. All right, can we go to the next slide, please?
Yeah. We're still
Sure.
having some problems, Lynn, just
Yeah, it looks like we're
FYI.
still having difficulties. Malcolm, would you mind reading that portion of the
Yeah.
slides? And maybe Lynn, if you want to sign out and sign back in, and that might
Yes, I'll
enable
do
a
that.
discussion.
I
And it-
apologize.
Yeah,
Okay,
and
great.
let me go. Yeah, because I think everybody's we've heard a couple of things, and let me just go back. Yeah, he fell out of his wheelchair, and as a consequence, the bottom line was that he needed a part for his wheelchair. He filed his insurance claim. They want the Stonebridge. It looks like took over a month to respond and requested additional information. Then they wanted a medical peer review. Everything that they were doing appeared to be something that they were doing for delay, because I think that's one of the facts that you always rely on in these types of cases. So he protested, and I and the question at the end of the day was, I think Lynn, are you back with us now?
I
Can
am.
you hear
Can you
okay?
guys hear me okay?
Yes, we
Okay,
can.
great.
So the question is that it says there was no indication that you had any medical conditions that required inpatient acute care and was not consistent with professionally recognized standards of care. So I think that's where we want to put the poll to the audience, right, Lynn?
Yes.
Okay.
So is
So
there sufficient evidence for punitive damages here? I think would be the question.
yeah. And the second question, if once you get past that, if the answer is yes, the question is what measure? How
Right.
outrageous is it? Or is it mildly outrageous or substantially outrageous? Let's keep an eye on the and you're all entitled to put something in the chat.
Or the Q&A, whichever
The Q&A,
works.
either the Q&A is fine. The answer is yes, there are enough facts for punitive damages.
Thank you, Lorraine, for participating.
Mhm. And another one of our viewers and listeners said, yes, I think he deserves punies, and I think the insurance company's behavior was substantially outrageous.
Yeah, good.
Well, I think that answers that.
All right. Should we go ahead and go to the next slide and look at some of the answers?
Yes, let's do it.
Okay. You went through this slide, I believe, already, right? That he protested. Yeah, we went
Yes,
through that slide.
yes.
So we
Yeah,
can go
all
to the
done.
next one. All right. So factor one, did the conduct cause physical harm? Actually, the court found no. The court found that the evidence indicated that his injuries were solely economic. The injuries arose from a transaction, not a physical assault or trauma. Now, remember, as empathetic and sympathetic as this patient was, right? He was paraplegic. He had suffered prior injuries. He served for our country. So an extremely sympathetic individual. And the court still found, no, this is purely economic and there's no physical harm here. He did claim he suffered emotional harm, which we'd expect in a case like this. And he relied on a case titled Roby versus McKesson, claiming that when a defendant's conduct causes emotional and mental damage, it is treated as a physical harm. The court still rejected that notion. They were not convinced by his citation to Roby. And just to give you a little insight on Roby, in that case, the plaintiff developed agoraphobia, became suicidal, forwent medical treatment, so didn't get treated, and was described as completely disabled due to the emotional harm caused. Nickerson had only felt strong emotions, but did not suffer any physical effects, the court found, the Court of Appeal. So that was the distinguishing factor there. So a little bit different, I think, than what the audience probably was honing in on. I think everybody's honing in on the insurance company's conduct, which is natural, right? And
Right.
not the physical harm to the patient.
Yeah, because he needed a part on his wheelchair. I think that was probably the pivotal fact for that
Yeah,
conclusion.
right,
How,
right.
how about and factor two?
Let's go
Next
to the
slide.
next one. So, did the defendant disregard the health and safety of others in its conduct? Again, we're focusing on the carrier here, the insurance carrier. The court found that the carrier disregarded the health and safety of Nickerson and others. Interesting, right? And by making that finding, the court relied on certain evidence that the carrier did not provide his doctor's letter to the peer reviewer and refused to recognize the necessary 109-day hospitalization. I think that was a pretty convincing, powerful fact there. 109 days, and they said 18 days or something along those lines. The carrier declined coverage on a finding that the VA hospital was not the most economically and medically appropriate hospital for treatment, despite the claim handler's concessions. That's also interesting, considering that this is a veteran that we're talking about here. My internet is unstable again. Can you guys hear me okay, Malcolm?
Yes, we can hear you.
Okay,
I was
excellent.
just going to comment on the claim handler's concessions.
Yeah,
I mean, I would like more information on that because it's sort of like what were those handlers, what were they conceding and at what point in time in the claim? And do keep in mind in many of these claims, the delays by the insurance company in an effort to sort of have the plaintiff give up is a tactic which was employed very heavily at one point in time.
definitely. And then they also relied on evidence that the carrier required Mr. Nickerson's care to be acute, despite explicitly stating this requirement in the insurance policy. Again, these are, more sort of, look, there's a document that says this, and yet they are doing something else. And then number 4, they expected him to return home despite his doctor's conclusions. That's pretty significant for the doctor to be saying, look, this patient needs to stay here. It's necessary. He needs to heal, whatever the medical opinion was. And yet the carrier went against that. I think that's pretty significant.
It is. Just focusing back on number 3 just a little bit. I mean, it delves into insurance law, but the bottom line is besides the normal language that we all know that contracts are going to be construed against a drafter. In the insurance context, they're going to be construed strictly against the drafter and in favor of the policyholder. That's the law. So if you want to claim a term that is sort of implied into a policy, that implication will not fly in court.
Yeah. So factor 3 is, did the defendant know the plaintiff was financially vulnerable and take advantage of that? Yes, absolutely. The court found that this patient was financially vulnerable. He was a disabled veteran of our country, 58-year-old paraplegic, living on a sole income of a military pension. So that factor, pretty easy for Nickerson's counsel, I think, to prove in this setting. Might have been different, right? Not a veteran, not a paraplegic. If it was someone that maybe had some other kind of condition that didn't debilitate them to that level, you might have had a different outcome on this factor.
Well, definitely in the disability context, you'll see if somebody has disability insurance through their employer and they have 2 other disability policies and they have a third one that is now where coverage is denied, but their standard of living doesn't change much because they have other disability insurance that helps them to pay the bills. They don't have to move out of their house. They stay the same. Everything's more or less stable, except for the fact that they don't have the additional money that comes from that last policy. At that point, it's going to be hard for for the plaintiff to argue. They're going to have to argue some change of circumstances, some vulnerability, something as a result of the denial of the policy. Doesn't mean they won't be entitled to the benefit of the policy if the carrier wrongfully denies it. But what it does mean is the emotional element and the financial vulnerability part of it is gone, which of course would shoot out a lot of the punitive exposure that the carrier might otherwise feel.
Exactly.
Malcolm and Lynn, I have a question. Maybe we could weave a few of these in because I know we have a time schedule tonight.
Mhm.
For punitives, I know we had talked about in our prep about looking at what a jury will award and what resonates with a jury. Can we? I know because you've done just such a great job of filling in all the other details that you took all my other questions. But I was very curious. What do you look at for juries? I mean, I know people do jury studies and focus groups and all things. What do you think are some effective ways to gauge what would resonate and a jury can relate to? Say, I'm mad. I want to order. Yeah, punitives are okay here. I think that's warranted.
I would start with the there, but for the grace of God go I. If you're able to humanize the impact of a certain situation where the jury can identify and relate and say, wow, if that were me, I would really be hurt, or I would be upset, or I would be angered, or I'd be depressed, or any number of things would have happened to me if counsel can present the plaintiff's story in such a way that you have the identification factor. I think a lot in the trial advocacy work that I've done, I've seen that that's where the jury says, yeah, that reminded me of what happened to my mom, sister, brother, or whomever, or to myself. And that's why it's covered pretty carefully in voir dire, because you want to know a little bit about those jurors, and that's what I would consider to be the most dominant factor is trying to get an identification factor between the plaintiff and the jurors. Lynn?
Yeah, I think that's probably the most critical factor. I mean, just going back to the Monsanto example for the moment, right? That's a product that the general public widely used, many years ago and maybe even up until recently. And, I can bet you that on that jury, there were people that used that product or they knew people that used it. And it gets the jurors thinking, wow, that could have happened to me. That could have been my, my husband that got the lymphoma. That could have been my neighbor, my mom, my dad, whatever. So I think that is critically the most important factor. I also think having the plaintiff be a sympathetic, credible, likable, relatable person. I think that's going to be very important to get that connection with the jury as well. But I think also too, it's the lawyers, right? I mean, Malcolm and I have seen in trial where, if the lawyers are able to connect with the jury in a way as they're making their arguments, doing their examinations, that goes a long way too. So it's all of those things sort of tied together.
And there's also I was going to talk about one of the stockbroker cases because that I had handled early on, and that's another. There were statements that were being presented to the plaintiff as the account eventually brought itself to zero. And what we were able to show is that the statements that were provided by the stock brokerage were almost hieroglyphics. That my client was the husband died, took the life insurance proceeds, put it into this account with this broker of an unnamed house, and it just kept churning down to zero. She had a high school education, married for 25 years, read the statements, asked questions, the broker wouldn't answer them. When I showed the statements to the jury, I said, "Do you understand these? Can you read this? Can you decipher what's going on?" And because of and defense counsel was sort of caught in a position of trying to say, well, no, it is clear, isn't it? And once that happened, I could watch the jury sort of move sideways and no, it's not clear to me. And so because they were trying to make an argument that the plaintiff, my client, was contributorily negligent for not reading and asking questions as her account eventually devolved itself to zero. And it was a very important moment. So the jurors afterwards had said the same thing to me. Said, yeah, I couldn't read that. I wouldn't understand it. So that's another thing. Show that they would have been confused in the same way that my client was confused.
Mhm.
So I think those are, wow. We're there, Hillary. Thank you for
right
that.
on the dot.
We're at the apex of the zenith.
We kind of addressed, I think, this one earlier, just quickly, you know,
Yeah.
if there's a pattern in practice of this, you know, this improper conduct, if we call it, that's obviously going to be much more detrimental to the defendant. And here in the example with our VA gentleman, the court found that the carrier's necessary treatment definition in the policy, again, the strict language in these insurance policies that Malcolm has mentioned, that was employed against other insureds to deny claims for hospitalization or emergency room visits. So in other words, the carrier had used the same tactic with other patients. Sorry, that wasn't necessary treatment. We're not going to cover it. And the court found that to be a problem.
We have a final question, and let's see if we can answer it before we sign off. And this question is, what happened to Nickerson?
What happened to Nickerson? Oh,
Yeah,
meaning,
I think the question is, if I'm not reading it incorrectly, is did he get any money?
I'm not sure actually.
Yeah, it's a great question because I'm not sure I know either, because the threshold question that it was not an injury rules out, of course, pain
Yeah,
and suffering. It doesn't seem like the emotional component was the court didn't see even though there's an allegation of emotional distress that wasn't really bought into. So all of these other factors played into it, but what did he end up getting as a result of that?
I mean, the court definitely found that there was concealment designed to increase profits, and it deprived Nickerson of his legal rights. So we certainly can look it up and get back to y'all to let you know if he actually received any monetary compensation or punitive damages. I just don't know.
And if you
offhand.
apply that to what we've already been talking about, that he only had a little bit of damage as a result of but this was a hospitalization policy, Lynn. So even if there
Mhm.
was a bolt needed on his chair, that wasn't probably covered under the policy.
Probably
So,
not.
so
No.
there may have been grounds, Lorraine, for punitive damages, but whether or not there was compensatory damages that you would apply the punitives against, it doesn't look like it. That's not our definitive position, but that's sort of a glib answer based on what we've all learned through these two sessions of the advanced trial tactics and punitive damages. Lynn, your thoughts?
No, I agree with that. I now I'm curious to know, so I'm gonna have to look it up as soon as we finish the meeting here. And if there's a way we can get a word out to y'all, we'll do that. But you can also look up the case. It's at 20 Cal Reporter, sorry, 209 Cal Reporter
Mm-hmm.
703. So if you want to look that up and take a read, that might be an interesting evening exercise as well. I think we're at the end here. Are we through the slides or?
I think we are. That's it.
Yeah. Oh, factor 5. We'll just let you know that the court found that the carrier did
There was
act with
trickery.
trickery and deceit. So
Well, because they played with the word necessary.
yeah,
That's really what happened.
it's all
You know,
semantics.
insurance companies have to be very careful when they talk about words like necessary, because it's in the eye of the beholder oftentimes. And so they better be very, very clear about what's necessary versus desirable. And that's where those cases turn on very often.
Yeah.
So, Hillary.
I was just gonna say, great job as usual. And unless you have anything else to add, and we'll be continuing our advanced trial tactics series. And if anyone in the audience or anyone else has any questions about or wants to see other topics to discuss about, please feel free to contact us. Malcolm and Lynn, thank you so much.
Thank you
Thanks
for
so
your,
much.
your assistance on all of these programs, Hillary. Good job. Thank you.
It's been
Have a
great.
good
We
night,
really
ladies.
enjoyed it. Have a great evening, everybody.
Bye-bye.